have 1 minute.
Yeah.
Yeah. Okay. And it just felt right.
Okay, guys, we would like to start the next shiur, so if people can come sit down, please. That would be great.
Okay. Before Aviva Wapner introduces herself, we just had one request. We've noticed that over time, people have the inclination to make comments sort of when they rise to one's consciousness. And it disrupts the flow of the shiur. We're here to hear the Maggid Shir or the Magida Shir. If you have a question, that's fine. And every Maggid Shir will stop at a certain point and entertain questions. So if you have something to say, please save it as a question at the appropriate time during the shir. But please refrain from blurting out, comments that arise to your consciousness, which we've seen kind of a slow increase in that over time, and we don't want to disrupt the flow of the shir, so we would appreciate that. As we go forward, the floor is yours.
Okay, thank you so much. Thank you so much for having me, Torah Mitzion and Mitzanim. I'll just start off with a little bit of a bio. My name is Aviva Wapner from Toronto, Ontario, Canada, and I was privileged to study in Netivot with Mora Debbie, the wife of Mr. Solomon, and I made Aliyah in 2016. I learned in Beit Midrash Migdal Oz in the Gush, and then I studied in Bar Ilan, Tanakh and Law. And after that, I completed my legal studies. I did my internship, I did the bar, and I retired at the age of 25. And now, Baruch Hashem, I get to spend, my day job is actually teaching Torah, which is a dream come true. I find it a lot more exciting than corporate law. But at the same time, I find it very interesting how in Israel there isn't such a huge gap between Halacha and Torah and our legal system in Israel. And that's what I want to focus on today. And it works out nicely because the Parshiot this week and next week do have a little bit of a legal theme. This week we get, of course, the Aseret HaDibrot, but we also have this interesting encounter between Moshe and Yitro. And Yitro decides that he's going to teach Moshe a lesson about how to run a judicial system. And so he helps Moshe establish the courts that he's going to use to judge the people of Israel. And next week, of course, is Parshat Mishpatim, which means in Israel, law. And the first pasuk of next week's parsha, source 1, is Ve'ela mishpatim asher tasim lifnehem. These are the laws which you will teach them, and this introduces our civil code in the Torah. And of course, Chazal do not just read this pasuk and stick with the pshat. They use this pasuk as the basis for a drasha in source 2, the Midrash Tanchuma. The Midrash teaches us. First, it asks a question. Minayin lebalei dinin shel Yisrael sheyesh lahem din zeim zeh. From where do we know that two Jewish people who have a dispute, and they want to take this dispute to court, sheyodim sheha'akum, in this case akum of Deit Kochavim, could mean star-worshipping idolaters. Let's understand it as non-Jews. Danin oto din kedinei Yisrael. These people are living in an interesting situation where there's a non-Jewish court which happens to judge people based on halacha. These non-Jews are very well versed in halacha, so they set up a court system based on halacha. And these two Jews might think, I could go to Beit Din, where Jewish judges will judge me based on halacha, or I could go to this non-Jewish court. Minayin, from where do we know she'asur lehizdakek lifnehem, that it is prohibited for these Jews to go to a non-Jewish court, even if those non-Jews judge them according to halacha? Talmud Lomar, and here comes the pasuk from source 1. Asher tasim lifnehem lifnei Yisrael velo lifnei kutim. Kutim here will also translate, just for our purposes, as non-Jews. These are the halachot which should be used by lifnehem, the Jewish people, and not non-Jewish courts. And I thought I was going to have a cleaner whiteboard, but apparently somebody made that common teacher mistake of using a permanent marker on a whiteboard. So I can't really erase this, but if we can look beyond what's underneath, I just want to see, we have this little square chart thing. If we have non-Jewish judges here and Jewish judges here, Sorry for those on the side who can't see so well. And here we have halacha. And let's call this square secular law. We just learned that non-Jewish judges, even if they're using halacha as their legal code, is that mutar for Jewish people to go before those judges? No. Which means we can probably infer by kal vachomer that if the non-Jewish judges are using secular law, that would definitely not be permitted. What about Jewish judges judging us based on halacha? And we call that Beit Din, Bezdin, depending on your cultural upbringing. And what we're going to try to find out in the first half of this year is what about this square over here, for those who can't see, Jewish judges who are judging us, but not based on halacha, judging us based on some secular legal code, which happens to be the case in most batei mishpat in the state of Israel. Okay, but we'll get to that in a moment. Just want to finish up source 2. If one goes to a non-Jewish court, the Midrash is very harsh and says, Shakol mi sheminiach dayanei Yisrael, anyone who forsakes Jewish judges, v'olech lifnei akum, and goes to non-Jewish judges, kafar b'kadosh baruch hu tchila, v'achrei chen kafar b'torah. This is considered kfira, a sort of blasphemy, not just against God, but against the Torah. Can I take questions at the end?
It's one quick
Yes,
question.
yes.
Is this the people who are bringing the case or the defendants?
The people who are bringing the case and the defendants. The ba'alei dinin, meaning the parties, both parties to the case, it seems, would be at fault. Okay. So now what we want to do for the rest of the first half of this year is try to understand this square here. Judges who are Jewish but do not use halacha when they're judging these cases. So the Gemara in Gittin uses this word again, lifneihem, from Parshat Mishpatim, that these laws should be before them. Lifneihem velo lifnei hedyotot. The judges should be what we call mumchim and not hedyotot. So a mumcha is an expert, a hedyot. I had my 9th grade Gemara teacher translated hedyotot for us as idiots, but I don't think that was a little bit too on the nose. Yeah, not an idiot judge, hopefully, but a non-mumcha, a non-expert judge. And the Gemara in Gittin takes issue with certain judges who were involved in authorizing Gittin, marriage divorce documents, I should say, without being experts. And the Gemara there seems to take issue with that. And now we're thinking, okay, not only Jewish judges, but they have to be expert Jewish judges, experts in halacha. The Gemara there already lightens this a little bit. This obligation is only when you have mumchin around. If you don't have a mumcha at your disposal, it's okay to go to your most learned Jewish judge available. And the Shulchan Aruch in source 4 paskins like this. First, he says we really want mumchim, we really want expert Jewish judges. He says, Kol hama'amid dayan she'ino hagun ve'ino chacham b'chokhmat Torah. Somebody appoints a judge who isn't a big Talmid Chacham, ve'ino ra'ui liot dayan, who really isn't fit to be a dayan. Af al pi shu kulo machmadim ve'yesh bo tovot acherot, even though he's like a very lovely person. The people who appoint this judge are violating a lo ta'aseh, because the Torah tells us, lifneihem, you should bring your cases before expert Jewish judges who know halacha. And now let's see how this qualification is, we'll see how this is qualified by the Ramah, the Ashkenazi gloss on the Shulchan Aruch. The Ramah tells us, I didn't bring you the full source, the full quote from him, but I'll first say that the Ramah points out that if somebody is going to choose between the Jewish courts and the non-Jewish courts, it is much better for them to go to a non-mumche Jewish judge than a non-Jewish judge. And what if we're in a city which has excellent non-Jewish judges, and unfortunately we can't find any expert Jewish judges to appoint? Better that we appoint a non-expert Jewish judge so people have where to turn so they don't end up going to the non-Jewish courts. And then the Ramah makes a beautiful statement in the bold in source 4, which gives us a lot of room to play around. The kol tzibur yecholim lekabel aleihem beit din she'inam ru'im min haTorah. A tzibur, a congregation, a community, can decide we communally, collectively accept judges who maybe by Torah standards are not really up to snuff. We're going to accept them, and this gives a lot of power to the community to decide who their judges are going to be. L'chatchila, ideally, that probably wouldn't be the case. The Ramah would probably say ideally, it shouldn't be about communal acceptance. It should be about really who is the most qualified judge, the most brilliant halachic scholar. But in a case where we want to prevent people from going to non-Jewish judges, or simply we don't have such amazing mumcha judges in our community, communal acceptance can work. to find judges who are qualified. So this square over here, we're thinking, okay, maybe Jewish judges who are mumchim, they don't have to know halacha super well, but can they go according to secular law? That remains to be seen. And the truth is that amongst the early poskim, the Rishonim, there isn't really anybody who speaks up for a secular code being used by non-Jewish judges, except for our friend Menachem Meiri, Harav Menachem Meiri in source 5. The Meiri was a very radical thinker in many ways, in many situations, and here he also understands a term in Masechet Sanhedrin, Erkaot Shebesuria. There were certain Erkaot, the Greek word for courts. There were certain courts in Syria and Syria, Jewish courts, where judgments were being made not according to halacha, and that seems to have been acceptable. And the Meiri describes these courts and says, Shelo hayu beki'in bedin haTorah. These people were not so familiar, baki, they were not so familiar and expert in Jewish law. So how would they judge people? Ela shedan le'omed da'at ubechukim unimusim. They judge people based on their own omed da'at, their own assessments, their own logical understandings, and also these words, chukim and nimusim, laws and customs. Not the laws and customs of the Torah. Apparently in Syria, there were Jewish judges judging based on other chukim, and they had the power of a Beit Din. These erkaot shebesuria were recognized as some form of a halachic Beit Din. So that, perhaps, according to the Meiri at least, might provide a basis for Jewish judges using other chukim outside of halacha to judge Jewish people. Okay, where does this lead us to in the state of Israel? In the state of Israel, most times you go to a Beit Mishpat, a court, as opposed to a Beit Din, and the judges you find there are, for the most part, Jewish. There are, of course, Arab Israeli citizens, some of whom have become judges. Some of them are Christian, some of them are Muslim, but most of the time, the judges you will find in a Beit Mishpat are Israeli Jews. Okay, so we can check that side of the box. And what are they using as their source material, as their code of law, Israeli law? And perhaps, maybe based on the sources we've seen, there might be a little bit of room for that because the Jewish people in Eretz Yisrael, the citizens of Israel, have accepted them as their legal authority. What do the modern poskim say about going to Israeli court? We'll see a little bit of a spectrum now. The first opinion that we'll see is the Chazon Ish. The Chazon Ish was a Haredi posek who lived in Bnei Brak. We will expect the Chazon Ish to be the most machmir, the most stringent of our opinions, because we know how the Haredi camp usually likes to fall on the stringent side of things. And the Chazon Ish writes, source 6, Shashofet kol din shelefanav, lefi hanira elav, zeu bichlal pshara. The Chazon Ish actually opens a little bit of a window for us by bringing up this idea of pshara, which means compromise, or what we would call mediation or arbitration. According to halacha, it's permitted to not go to Beit Din at all. If you have a dispute, you could just ask your neighbor, would you like to sit down with me and Ploni, me and my other neighbor, and we're having a dispute, and could you work it out for us? And if we trust our neighbor enough, we could tell him, you don't have to go according to the din, according to what halacha says in this case. You could just judge us based on what you think is right. And, that's okay, even according to the Chazon Ish. The ein, and why is this okay? The ein nikar hadavar, it's not so nikar, recognizable, when you go to your neighbor and ask him to mediate for you. Sha'azvu mekor mayim chayim lachtzov borot ushvarim. It doesn't look like we have left the be'er mayim chayim, the well of the Torah, and gone to, dig our own wells. The metaphor that the Chazon Ish is saying, when you go to your friend and ask him to adjudicate for you just based on mediation, you're not really putting aside the Torah. When does it really look like you're putting aside the Torah, though? When you choose an alternative legal system, not just another person. And he writes, Aval im yaskimu al chukim. If we get together as a Jewish society and agree upon a new set of laws, harehem mechalalim et Torah. This is a violation. This is a chilul, a desecration of the Torah. Ve'ein nafkuta. There's no nafkamina. There's no practical difference. Bein balifnei enam Yisraelim uvein Yisrael sheshofet al pi chukim v'duyim. The Chazon Ish equates going to a non-Jewish judge and going to a Jewish judge who's judging you based on secular law. Ve'od hadavar yoter meguneh. It's even worse. Shehimiru et mishpatei Torah al mishpatei hahevel. We've forsaken the Torah laws and gone to hevel, to nothingness. Ve'im yaskimu b'nei ha'ir al zeh. And you might be thinking about the Ramah, who said that communal acceptance is good enough. No. If the community accepts not just non-expert judges, but a non-Jewish court system, Ein behaskamatam mamash. This haskama, this communal acceptance, does not have significance, does not have weight. So that was the right side of our halachic spectrum, the posek from Bnei Brak, who we expect to be the most harsh, always. We know how the Chazon Ish rules in other cases. He's a very stringent posek. And we might be thinking, okay, now that we'll move perhaps towards centrist orthodoxy, we'll get a little bit more of a lenient position. And so we'll see in Source 7, Rav Yitzchak Halevi Herzog, the Rav Herzog who was around at the Kom Hamdina during the foundation of the state, and he was the first Ashkenazi chief rabbi and of the state. And it's interesting that maybe counterintuitively, Rav Herzog is going to be even more harsh on this idea than the Chazon Ish. And why is that? Because the Chazon Ish doesn't fundamentally see the state of Israel as the flourishing of our redemption, as a religious Zionist project. He sees Eretz Yisrael as a holy land, Medina Yisrael as a treifa Medina, and, he happens to live there. But the Rav Herzog and other Dati Le'umi, early religious Zionist poskim, they hope to see in the state of Israel a state of real religious significance. So it hurts these religious poskim, these religious Zionist poskim even more to see that the Jewish state of Israel is choosing a non-Jewish legal system. And he writes something that Chazon Ish did not go so far as to say, but he writes, Source 7, Uledati elef pa'amim garua. It is 1,000 times worse to go to an Israeli secular court than to go to, the courts of Canada, if you're living in Canada. Mikol yachido yechidim o keilah holchim le'erkaot shel goyim. This word erkaot, again, the courts of non-Jews. It's 1,000 times worse to go to a court of Jews. Kisha Am Yisrael be'artzo betor shekazeh, when Am Yisrael is living in our land as the Jewish people, dan al pi chukim zarim, are being judged according to non-Jewish laws. Hamibli ein Elokim b'Yisrael. Do we not have a God of Israel? Do we not have our own Torah that we have to go and take laws from the British mandate in the Ottoman Empire? Because Rav Herzog, he dies in 1959, and he's living through the birth of the state. And during that time, we didn't really have, the energy during the Independence Day War. We weren't writing our new laws. We were just really adopting the laws of the people who ruled this land before us, the Ottomans and the British. And he sees that we're not doing anything to create an independent Jewish legislature, and that really pains Rav Herzog. I wonder how Rav Herzog felt about his son, Rav Yaakov Herzog, becoming a lawyer. And I actually studied law in Bar Ilan, and Bar Ilan's law school was named after Rav Yaakov Herzog. And at my graduation, the current Rav Yitzchak Herzog, the president of Israel, decided to come and honor us with his presence, and we had to wait a really long time to start the ceremony because he took a really long time to get there, and once you invite him, you can't really start without him. And it was the middle of July, boiling hot, sitting outside in the amphitheater at Bar Ilan, just wishing they hadn't invited the president. But they did, and he made a speech about his grandfather and his father, what they thought about Israeli law, but funny enough, he didn't mention that it's 1,000 times worse to study secular Israeli law than going to a non-Jewish court. I'd love to ask him about that. So far, I don't think we have much luck in permitting somebody who wants to be halachically observant to go to an Israeli secular court, because even Rav Herzog did not allow it. And the one person we're going to see who is very much in favor of it has a little bit of a conflict of interest, because while he is an Orthodox rabbi in Source 8, we're talking about Professor Menachem Alon, who was also a Supreme Court justice in the Israeli secular system. And he was a big proponent of Jews, religious Jews, going to court in Israel. And he brings several arguments. So we'll see in Source 8. Tana zo bidvar kiyum isur halicha le'erkaot, b'hitaynud lifnei batei mishpat sheyoshvim behem shoftim Yehudim. He's like, to even compare our legal system to the erkaot, shebisuria, the erkaot of the goyim, the non-Jewish courts, when we have Jewish judges, hadanin shelo lefi halacha, yes, they're not using halacha, keshehi nitenet umushmat b'yameinu, tmuahi. We can't really argue that there's an equivalence between going to a Jewish secular court and going to the non-Jewish courts. Le'or hashinui hamuflag shachal b'shmirat isur halicha le'erkaot shagoyim, me'az bitula shel ha'autonomia hashivutit ha'ivrit. He's taking us back in time 2,000 years, and he's saying, when did this isur of going to a non-Jewish court apply? That's when, before the Churban, we had the Sanhedrin. We had a functioning Jewish legal system, and so if you abandoned the Sanhedrin and instead you went to a Roman court, that's when this Isur was in full force. After we were exiled by the Romans and we went into non-Jewish lands, there we wouldn't really say that we had the option to go to a Jewish functioning court. So that Isur hasn't really been in place for so long. לא זו בלבד שמאז ביטולה של אוטונומיה זו, הלכה ורבתה הפנייה לבתי המשפט של מדינה בכל מרחבי הגולה העברית. In Morocco, in Poland, in the whole Jewish diaspora, Jews went to their non-Jewish courts that they found in those areas. And Chachmei Halacha hishlimu im tofa'a zo. Hishlimu like shalom. They made peace with this. We never saw a huge rabbinic outcry about Jews in Morocco going to the local courts. Now, Alon is claiming that. I can't say I've done the research and looked back at 2,000 years of Jews living in the diaspora and how their local rabbis reacted to them going to the authorities for non-Jewish adjudication. I'm not sure if that's true, but Alon claims that it is. He claims rabbis never really cared about Jews going to non-Jewish courts in the diaspora. Ukayom hazeh. And now that we're back in the state of Israel, Ponim Yehudim Shomrei Torah umitzvot kala kevachamura lebatei mishpat shel medinat megureihem. He says there are plenty of religious Jews, let's say in California, in Europe, who go to their local non-Jewish courts, bechol merchavei hatfutza yehudit, in the whole diaspora. So he says if there's no outcry when Jews do that in chutz la'aretz, yoter mitamuahu efo lahalo tana shel isur halicha le'erkaot. Why dafka would we take issue with Jewish people going to secular courts in Israel? Well, we know why. Because it's so much worse when a Jewish person decides he's going to judge according to non-Jewish law when he could judge according to halacha. But what is Alon's argument? He says in secular courts in Israel, asher ba hamishpat ha'ivri hu ben bait ulefachot oreach matzui. He makes a claim that a ben bait, like a constant presence. There is the constant presence of mishpat ivri in secular Israeli courts. What is mishpat ivri in secular Israeli courts? Mishpat ivri is the blanket term for halacha, but not halachot of kashrut and tefillah and holidays. Anything that has a civil parallel. So the halachot of hashavat aveidah, for example, and the halachot of property, all of those things fall under this umbrella of mishpat ivri. And Alon claims that mishpat ivri, that halacha, is a ben bait in secular Israeli courts, or lefachot oreach matzui, or at the very least, a matzui guest, a common guest. Alon is making it's a bit of a stretch here. He's claiming that you walk into an Israeli secular court, you listen to the judges, and I hear them quoting the Rambam. I hear them quoting the Shulchan Aruch. Does that happen so frequently? Perhaps, perhaps not. I will say that in during my degree in Bar Ilan, we had to study a lot of halacha to pass our finals, and I really enjoyed that. I liked that, I had to study Israeli contract law, Israeli dinei nezikin, which is not Seder Nezikin, but it's just the same word that we use, but it was a secular nezikin law. But I also had a class on kibud av ve'em and adoption and surrogacy and halacha, and I had a class on the history of the Sanhedrin and how the ancient Israelites used to go to court. And it was just very nice to have an advantage because as a native English speaker, I was always nervous about studying law in Israel and how it would be to do everything in Hebrew. And I was like, this stuff I think I have a leg up at least over Mohammed, who's sitting next to me also trying to understand the Shulchan Aruch. And it was very interesting. Some classes they said, okay, turn to the person next to you and learn the Chavruta. And I was like, okay, like my friend here from some Arab village in the north. It was just very interesting that at least there I felt like I had a bit of an advantage. And unfortunately also over plenty of the Jewish students who don't come from a religious background. But what I want to do now, with the time that remains, is I want to look at a case study. Literally, I want to look at a case from Israeli secular law from the 1970s. And I want to see if Alon's claim holds up. Alon claimed that Mishpat Ivri halacha is a constant guest in the Batei Mishpat, the secular courts. I want to see actually, is halacha such a common guest in secular court, and how welcome of a guest is he or she? Because we will see some of the judges are inclined to include halacha in their psak, piskei din, I should say, and some of the judges are going to be less welcoming of halacha. So before we read the case from 1976, we have to learn a little bit of halacha, of Israeli law, I should say, the lost property law from 1973. And what do you notice just first about the title of the law? The law is not just from 1973. Israeli law also records that it's from 5733. The legal system in Israel is very respectful of also the Jewish calendar, the Jewish year. And the Hebrew name for this law is Chuk Hashavat Aveidah, borrowed from Halacha. Okay, let's learn a few of the seifim, a few of the sections of this law. And then I promise we'll get to the case, which is more interesting than the very, very dry law. Okay, clause 2 of this law, a person who finds and takes possession of lost property, the finder, is obligated to return it to its owner. Okay, that we can understand. Or to report it immediately to the police. So a finder has two options. Either return to the owner, report to the police, unless the circumstances of the case lead to the presumption that the owner has despaired of the property. This is something we recognize from Halacha. Yeush. But in Halacha, we have many different factors to understand when Yeush has taken place. And here, the only case where we're sure Yeush has happened is due to its minor value. If somebody lost a tissue, we don't have to chase after them and try to give it back to them. But basically, the first two options are try to return the item to its owner or bring it to the police and have the police take care of it. A person who finds lost property in the domain of another person is obliged to report it to the owner of the domain and hand it over to him upon his demand. So here we're talking about the reshut of another person. And what's interesting is that this law does use the word reshut in the Hebrew version of the law. It says reshuto shel adam acher. And we're going to see the debate amongst the judges was, should we read reshut as a halachic term or simply as a word chosen by the legislator, the mechokek, without halachic significance? And finally, if the finder has fulfilled the provisions of Section 2, bringing the object to the police or bringing it to the owner, or I guess holding on to it for the owner, and the owner of the lost property has not been ascertained within 4 months, it shall be presumed that the owner has despaired of it. Then we assume Yeush has happened, and the finder shall become the owner of the lost property. Okay, with all that in mind, we can now read the case and understand what happened. This is the case from 1976, Eliezer Hendel's versus Kupat Ha'am Bank, which is now defunct, but has anyone heard of Kupat Ha'am? No one's been around that long. Okay. In Israel, on April 22nd, 1976, Eliezer Hendel's entered the Kupat Ha'am Bank. He entered the safe deposit box room and found an envelope on the floor containing 2 bonds entitling their owners to 20,000 lira, also defunct, and hopefully no one's been around that long either, with no owners specified. The branch manager demanded that Hendel's hand over the envelope, but he refused. He preferred to hand it over to the police, who took possession of the lost bonds according to Chok HaShavat Aveda. Why was the bank demanding that he hand over the bonds to them? Because they claimed you found it in the safe deposit box room. That is our reshut. That is the reshut of the bank. After 4 months, great, we know 4 months is important, during which the identity of the owner was not determined, Hendel's contacted the police and asked to take possession of the bonds. The police refused his request, opting instead to hand them over to the bank. So we see whose side the police are on. The police believe, the safe deposit box room, that's part of the bank's reshut. We'll give this envelope to the bank, because the envelope was found there. Hendel's sued the police in district court. So we have several levels of courts in Israel, and district court is the Beit HaMishpat HaMachozi. The court turned to Mishpat Ivri to understand the status of the room where the bonds were found. So here we're seeing our guest has arrived. Mishpat Ivri Halacha has arrived in the district court, and the judge there, Yehuda Weiss, decided he was going to not just open the Shulchan Aruch himself and say, hey, what does Halacha think in this case? He does something a little bit more extreme. He brings in 3 poskim, and he, almost like an expert witness, like you bring in a doctor or a forensic analyst to your court, he brings in 3 poskim, and he says, what would you do in this case? And based on the expert testimony of these 3 halachic scholars, the court determined that the room had the status of a reshut harabim, the safe deposit box room, because it is open to the public. Many people can enter there. Because specifically it is not a chatzer hamishtamer. This was not a guarded chatzer. It's not an area where anybody is preventing you from entering. Therefore, it must have been a public thoroughfare. And if the bonds were found in a reshut harabim, who gets to take them home? Hendel's. Therefore, Hendel's was the owner of the bonds. And of course, the bank now appeals this decision, and we are going to follow this case to the Supreme Court. And we already know one of the judges who is going to be sharing his opinion in the Supreme Court. Another judge we have to mention is Justice Aharon Barak. And Barak has, earned quite a reputation, especially right before the war. We had a lot of tension because of the judicial reform that was on the table, and that has to do with Israel's constitutional law and the powers of the judiciary. And Aharon Barak, just parenthetically, was what we call the father of Hama'apecha HaChukatit, the constitutional revolution in Israel, because he was the first judge to use our Chukei Yesod, or semi-constitutional laws, in order to strike down a law that the Knesset was trying to pass. So In a nutshell, Aharon Barak, we'll see how he feels about bringing Israeli, halachic poskim into court. And he's still alive now, he's 89, and Barak writes in the Supreme Court, Halacha in our context is a legal system that provides judicial inspiration through legal comparison. And Halacha is great. You can use it to do some comparative law. It is studied from books open to the public. He means if the judge wants to use Halacha in his case, he should just open the books on the wall and not bring in poskim into his court. It does not seem proper to me under these circumstances to rely on a specific question directly related to the subject matter of the case, which was commissioned for the purpose of the case, and the answer provided in its wake. It was inappropriate, Barak argues, that the judge in the district court was bringing in these poskim and asking them this question that pertains so closely to the case at hand. He thinks that was an inappropriate use of Mishpat Ivri in an Israeli secular court. Who is going to disagree with him? Our trusted friend Menachem Alon, who again told us that he thinks there's no halachic problem for an Orthodox Jew to go to a secular court, because he's going to argue halacha is right at home in our secular courts. Now, they all start with all due respect. They're all very respectful. With all due respect, I disagree with my colleague's qualification. The learned judge from the district court stated, so first he says, when Yehuda Weiss in the district court, when he brought in halachic poskim to his court, he wasn't saying he was going to accept their psak unequivocally. He said the material will be accepted as non-binding legal material within the framework of theoretical research. He's just getting inspiration from these poskim. And then I think Alon has a very funny bit here. He says not only is there no fault to be found in this, but it actually promotes and facilitates the ability of Israeli judges to study the rules of halacha. As is known, this study is sometimes fraught with great toil. I think Alon is saying this a little bit tongue-in-cheek, that really Israeli judges are supposed to have a working knowledge of halacha, and Alon definitely has that as a rabbi. And I think maybe he's saying many of his colleagues, unfortunately, don't have the same skills when it comes to navigating halacha, and bringing a posek in for them might be just what they need in order to be able to answer questions that come up in cases. Why should we not ease the judge's task by presenting expert opinions from scholars of halacha that clarify the position of halacha on the issue at hand? Of such matters, it should be said, Kol hamarbeh lesaper b'mishpat ha'ivri, from the Haggadah, Kol hamarbeh lesaper b'yetziat Mitzrayim, leta'aro, to explain, lahasbiro, hareza meshubach. Very alone. And these expert opinions are capable of assisting Israeli judges in clarifying the law and issuing judgment, as was indeed the case in the matter before us. So Alon is like, I see no problem bringing a posek into court. Now, Alon is not mentioning, and nobody's mentioned thus far, what about non-Jewish citizens of Israel? What about non-observant citizens of Israel? Did they necessarily want to come into court, think they're going to be judged by a secular Israeli judge, or at least a religious judge using secular law, and then all of a sudden somebody's pulling out the Shulchan Aruch on them? So Alon does not mention that. He's still just focusing on the judge and the art of judgment and how poskim could be led into court for this purpose. But he doesn't go all the way and say we're going to turn into Medinat HaHalacha. Alon finishes off by saying, certainly the interpretation of legislation according to halacha is inappropriate when a specific law clearly contradicts halacha. So if we're trying to understand, should we permit the import of pork into Israel, we're not going to look at hilchot kashrut. Those two things just simply don't go together. But when the situation is not so, and a doubt arises that cannot be resolved from within the law and its content, we must resort, first and foremost, to the principles of halacha, which are not binding, but which can guide us in solving the problem before us. Okay. Now that we've understood Alon's position, Alon does something very convenient for us. He makes us a little source sheet, and he goes through the relevant halachot in this specific case about the bank. So he quotes for us, and I just love doing this when I teach my students, like cases like this, my seminary students in Mishpat Ivri. I always have to remind them, I didn't read the case and then put together a source sheet with, some nice halachic sources that happen to fit nicely with this case. The judges all did this for us, which is very convenient for me, and also just shows us how much halacha really does show up sometimes in cases. Like how many times have you been in court in New York and the judge starts quoting Bava Metzia? So the Mishnah of Bava Metzia teaches us, if one finds an item in a store, those items belong to him. If I walk into a makolet and I find 50 shekel on the floor of the makolet, I actually do not have to give, according to halacha, I don't have to give those 50 shekel to the owner of the makolet, because this is not the reshut. The makolet is not the reshut of the owner of the makolet. Why not? Because he doesn't have guards up at the front of the store. I mean, in Israel, it's strange because we do have security guards right outside the mall. Unfortunately, we have to have that for security. But your local makolet doesn't have a guard at the entrance. Why? Because the Rashba tells us the storekeeper wants the masses to enter his store. It's the opposite of Reshut Yachid, where you want to keep people out. A store, you want to bring people in. And if you're open to having the masses enter your store, you can't really claim that it's a Reshut HaYachid anymore. And we also have a concept in Halacha of Kinyan Chaser, which is that if an object is in my property, it automatically becomes mine. The Rambam tells us, why does the store not acquire the lost object on behalf of the storekeeper? Because the store is not a Chaser HaMishtameret. So if Hendel's, in our case, had found this envelope in a store, would it have been his?
Yep.
Yes. You might want to argue, okay, fine, that's a store. A bank is a little different. The bank isn't trying to sell you apples and oranges. The bank maybe is more similar to a Chaser HaMishtameret, a private domain, a guarded area. But no, the Mishnah goes on and talks about a money changer. And a money changer has a bit of a pretty similar deen as the regular store, except in a money changer's room, we have even today the table where the money is put, and we have that glass divider. And the Mishnah tells us, if one finds coins before a money changer, those coins belong to him. If I would just walk on Ben Yehuda, you have all those like currency exchange places. I walk in and I see the 50 shekel on the floor, that's mine right away, because many people are encouraged to go to that part of the store. If the coins were found between the money changer's chair and the money changer, those coins belong to the money changer, because his clients do not typically have access to that area. Oh, so if we're talking about the area in a bank, let's say, where only the teller has access to, okay, if I find money there, I can't really claim that's in a public domain. That's in the domain of the money changer, of the banker, of the teller. But what will we say is the status of the safe deposit box room? Is that cut off to the public? No, the public can enter that room if they have reason to. You don't have to be authorized personnel to go there. And if we want to compare that maybe to the table at the money changer's in the money changer's store, plenty of people put money there, and the money changer takes the money off the table. And the Torah tells us when it comes to exchange money, places coins on the money changer's table. Therefore, coins being present on his table doesn't indicate ownership of the coins, his ownership of the coins. We can still say that those coins were brought in by someone, a member of the public, and now they can be taken again into the possession of any member of the public. And Alon brings all these sources, and he says, based on these sources and the opinions of the poskim brought in the district court, I think Hendel's has a right to the money. So, Alon is in favor of upholding the district court's decision. Unfortunately, he is overruled. Barak and the third judge, they win, majority rules, and Alon does not get to take home the win, and Hendel's does not get to take home the money. The judgment of the district court is overturned, and the bank gets possession because the other judges simply read the word reshut in Chok HaShavat Aveda as the domain, not as the reshut harabi versus the reshut hayachid. They don't assign halachic weight to that term. Now the bank is very happy. They get their 20,000 lira, which I'm not even sure how much that would equate to today. I'm sure we could look it up. And Hendel's gets nothing. And Hendel's is in a bit of a pickle because he wants to appeal, but this is a Supreme Court ruling. You can't appeal, except you kind of can. He could go to Beit Din, but he's not going to Beit Din. He's going to Bagatz is a little bit different because Bagatz, you can only go to Bagatz if you have a complaint against the government or the Knesset. In this case, Hendel's requests something called a diyun nosaf, an additional hearing, which sometimes, we add more judges. Sometimes the Supreme Court will decide when there's something that's on the table that is of such critical importance, not just to this one case, that has far-reaching implications for many other cases, then they'll decide we're going to reopen the case and do another hearing. And in this case, what was on the table? What was the big question? Not 20,000 lira, who gets to take it home in the envelope, but how much is Mishpat Ivri allowed to play a role in our legal system? And for that reason, they reopen the case and they have an additional hearing, a diyun nosaf. Before we see the diyun nosaf, we have to also realize that in 1980, this is now like 1981 when the diyun nosaf happens, in 1980 the Knesset passes a very important law, which has implications for this case. The Foundations of Law Act, Chok Yesodot HaMishpat, tells us, Ra'a Beit HaMishpat, She'ela Mishpatit, Hatu'una HaChara'at. The Beit Mishpat, if any court is faced with a question that needs to be resolved, V'lo matzala tshuva b'dvar chakika, and they can't find an answer to their question in any legislature, or b'halacha psuka. Ironically here, they're not talking about halacha psuka. It means in a precedent. They don't have precedent for this. O b'derech shel hekesh, also not a halachic hekesh that we're using in the Gemara, but just using the same word hekesh by means of comparison. So there's a legal question that can't be solved in any of the normal avenues. Yachriya ba'leor akronot ha'cherut hatzedek hayosher v'shalom. They should follow the principles of integrity and tzedek and shalom of hamishpat ha'ivri u'moreshet Yisrael. Mishpat ivri halacha and Jewish tradition. Until 1980, if there was a lacuna in the law, if there was some sort of gap in the law's instructions, what were the judges supposed to do? Something called Article 46 mandated that the judges had to look at the laws from the British Mandate. They had to go back and they had to look at British law if they wanted to fill that gap. And in 1980, the Knesset passes a law that says we're not going to rely on the British anymore. We're actually going to look at halacha when we have an important question that we can't resolve in any other way. But let's read it carefully. The law doesn't say halacha. It says mishpat ivri, which we know is a term that does encapsulate parts of halacha, and moreshet Yisrael. Sounds nice, but what does that mean? Jewish tradition. And it also doesn't say that we're going to use those two things, moreshet Yisrael and mishpat ivri, to answer our questions. We're going to use the ekronot, the principles of tzedek and yosher and shalom that are behind those things. So we shouldn't read this law as like okay, we don't know what to do on the books, we're going to open the Shulchan Aruch. That's not what this law is requiring of us. And this law is now going to play a role in the additional hearing. I didn't bring you what Barak and what Alon say in the additional hearing because they basically reiterate their previous positions. Barak says, we don't have room for halacha in our courts in the way that it was done in this case. It was too much. Alon says, Kol ha'marbel saper b'mishpat ivri harizah meshubach. And Justice Landau, a third judge, and there's additional judges who are added for the additional hearing, he decides to really analyze this new law, the Foundations of Law Act. He says, it is inappropriate to make fixed rules on this matter or to adopt a principle of interpretation that requires resorting first and foremost to halachic sources to resolve a doubt. He thinks it's inappropriate to say that we have to look at halachic sources, even though the law says that. I find the idea of obligating the interpreter to turn specifically to one source and no other merely to receive inspiration contradictory. He thinks there's a bit of a contradiction here. I have to look at halacha when I have a question, but only for inspiration? That the obligation and the inspiration are not sitting so well with Justice Landau. The Foundations of Law Act, he also points out, what I pointed out before, refrained from mentioning halacha by its explicit name and instead chose a concept that was previously undefined, moreshet Yisrael, which itself still needs to be understood through interpretation, and the task will not be easy. I do not believe this synthesis between law and halacha will be achieved by forcing the demands of our society into the fixed framework of the halachic legal system. And so this is something that I was thinking about before that I mentioned. There are many people who do not want halacha forced on them. I think he's alluding to that. Some people do not want to go to court and find themselves being judged basically by a Beit Din. And he says, based on its fundamental approach, halacha is a legal system that demands full unreserved recognition from the individual. Halacha isn't something that you can really coerce people into. It has to be something that they buy into if you want it to work, if you want it to mean something. So he ends with, we should enrich our legal thought from the treasures of halacha, which embodies the wisdom of life of our ancestors, and relate to it with reverence. Okay, great, reverence is good. But let us maintain our freedom of choice, the members of this generation, according to the needs of our time, without requiring a specific prioritization for our sources of inspiration. And then this is really important that he says at the end, and without placing the burden of proof upon the interpreter, requiring them to show in every case why they are unwilling to resort to halacha. He says, let's not make halacha the default, such that any judge who doesn't want to bring halacha into his courtroom or her courtroom has to now explain why they're not using halacha to judge. That's something that we don't want. We don't want everyone to have to excuse all the time why they're not following halacha in their cases. And the additional hearing actually renders the same result as the Supreme Court decision. They decide, we're sorry, Hendels, we're still going to side with the bank on this because we're not going to go with the Mishpat Ivri, the halachic interpretation, as our primary source of law. And this case had many, far-reaching implications. Basically, this is what happens today in Israeli court. Halacha is sometimes brought in as a source of inspiration, but it's not something that is, functionally deciding cases for us. And I just wanted to give us some statistics. About 5% of all Israeli legal cases have any mention of halacha in them. And even justices like Alon, who's a huge proponent of Mishpat Ivri, you know what percentage of his cases mention halacha? Only about 15 to 20%. So he himself, it's not like he's really like a dayan in Beit Din. He's still limiting himself to a small percentage of his cases. And if Alon's argument that we saw in the beginning was, why is it okay to go to a secular Israeli court? Oh, because halacha is always being brought up in those courts. Is that really true? I'm not sure it's so true, and I'm not sure that we could say that our Israeli courts are really like a Jewish court with Jewish judges and Jewish law, and the secular law there is not so secular. I think that's a very hard argument to make. So what do you do now? Where do you go to court? So obviously, halachic poskim would prefer that you go to the Beit Din, except in three major areas of law. Criminal law, we definitely do not go to Beit Din. That is something that all poskim say, take that to the police and the right authorities and the secular Israeli courts, just because we don't have, Batei Din do not have the power to really get involved in criminal cases and, to impose the right sanctions and punishments that criminals need. Corporate law, anything that has to do with corporations, the idea of a corporation, of a chevra, a company which stands independent of the owners of the company, is just not really recognized in halacha. They don't really have that concept. So corporate law, definitely we can use the Israeli secular system for that. And anything that has to do with international law, again, like the Batei Din didn't really have the power to engage in international relations. Okay, and what about my friendly dispute with my neighbor, which does not fall under criminal or corporate or international law? So in those cases, poskim really encourage one to get a heter before they go to Beit Mishpat. Most Batei Din are very willing to give you a heter, called a heter erkaot, a heter to go to the Greek erkaot, just kidding, to go to the modern erkaot. And ideally, one should get a heter before they go to court if they feel like for any reason whatsoever, the secular court will give them a more just outcome than the Beit Din. And I should say also, in Israel family law, the legal requirement is to go to Beit Din for things like ditin and marriage and children, and many of those things just naturally fall under the purview of Beit Din and not Beit Mishpat. So, God willing, we're living in a very interesting time in the state of Israel, and we should see more halacha being incorporated into Israeli courts, and perhaps one day, a fusion, a revival of Sanhedrin, and a fusion between the way that our state is run and the way that halacha dictates. Shabbat Shalom.
What about
Yeah, question.
Let's say the transparency. They don't have.
Yeah. So going to a Beit Din, and if you feel like there's going to be any problem with getting the just outcome that you deserve, it's better to go to a secular court. And to get a heter as a formality, there is an organization called Chokhmat Nashim, which has actually started something called Rate My Beit Din, which is a little bit like Yelp, where you can rate the Beit Din experience you had there, and then that gives a little bit of pressure on the Beit Din to improve their policy. Any other questions? Yeah.
Two things in common.